Hi everyone, I'm so excited to be able to come to you again the second day in a row with good news in the world of immigration. Our firm wanted to go live as soon as possible to let you know of a change that happened in the realm of public charge. So a federal judge in New York blocked the changes that happened with the rule of public charge that had occurred in February of this year. And so before I jump into why this is good news and exactly what it means, I'd like to introduce you to our firm and to who I am. Our firm is called Corrado Pastrana, the immigration firm for couples, and I'm attorney Megan Pastrana. Our firm is completely dedicated. We work exclusively with couples going through the immigration process. And so we're always keeping up to date on what's happening in the world of immigration and bringing you updates on our YouTube channel. So if you haven't yet subscribed, please do so. So what is the good news? What exactly does it mean that the public charge rule has been enjoined? So to give you a little bit of background for those of you who aren't familiar with what public charge is an area of immigration law that has existed for a very long time, and it basically says that an immigrant who's applying for a green card has to show that they're self-sufficient and that they won't need government benefits. And that was always something that you were able to prove by filing an affidavit of support. So for many of you going through the immigration process, you've probably heard of an affidavit of support. But what happened was on February 24th of 2020, earlier this year, the Trump administration made additional changes to that area of law, to public charge, making it more difficult for immigrants and creating additional obstacles and paperwork that immigrants had to file to prove that they would not be a public charge. A lot of the additions to that rule and the changes that the administration made were based on whether or not the individual could speak English and whether or not they had health insurance. And there was a lot of discriminatory angles that change was taking, like so many changes that this administration has made in immigration. And so immigrant rights attorneys filed 2 lawsuits against this change to public charge based on the fact that we are going through a national crisis with COVID, and these additional barriers and immigrants are worried about accessing health benefits because they're afraid of the public charge implications. And so these immigrants' rights attorneys successfully argued that these additions to public charge make it, they actually say in the opinion that was released that it's a lethal decision because immigrants are afraid to access healthcare. They're afraid to really do anything that would have an impact on public charge. And they argued that immigrants should be able to use healthcare, especially during this COVID crisis, this healthcare crisis. And so the judge in New York decided that the arguments made by these immigrants' rights attorneys were correct. And so he enjoined the government from continuing the implementation of these public charge rule changes. And there were 2 decisions. One was for the Department of Homeland Security, which is USCIS. Another one is for the Department of State, which is for individuals who are applying abroad at consulates and embassies. And so these 2 decisions, what it means when a judge enjoins an action is basically it means that the judge has blocked immigration from continuing to use those standards for public charge, that they are not allowed to assess an individual's likelihood of becoming a public charge based on the changes in February of this year. So that is great news. The additional paperwork, there was additional forms that had to be filled out. If you're going through an immigration process, you've probably heard of the Declaration of Self-Sufficiency, or if you're an individual that's applying abroad, there was a separate form that you had to fill out answering lots of questions about your financial background, your debts and income and things like that. And so the judge has said that they're not allowed to do that. So that's why it's great news. It's basically blocking these additional hurdles that have been put in place. And so it's important to know that this injunction is temporary. So it's not going to solve the problem forever, but the injunction is temporary based on whether or not the COVID crisis is still considered a national emergency. So while COVID is happening, the public charge changes have been stopped. So that's extremely great news. And I also don't want us to get ahead of ourselves. We don't have a lot of guidance yet. The decisions were made just yesterday by the judge, and so the next step will be for the Department of State and the Department of Homeland Security, for all the immigration offices, to decide exactly how they're going to implement these changes. So they're bound to follow this rule, but we have to wait for them to release guidance for us to have more clarity. And so hopefully that will be happening soon, and we will of course go live to give you updates. What we would recommend is that if you are doing your immigration case, that now is a great window of opportunity to make sure you get that filed, because you wouldn't have to be subject to these additional hurdles. But again, we need to wait for additional guidance to see exactly how this will play out. So again, so excited to get to share with you this great news. If you haven't already joined our Facebook group, Immigration for Couples, we would love to have you there. We're actually going to have a live chat today to discuss this, K-1 visas, and many other updates in the world of immigration as it relates to couples. And also please subscribe to our YouTube channel. As I mentioned, we love to give updates. We love to make sure we can inform the community, couples who are going through the immigration process, exactly what's going on in the world of immigration. So thanks for watching.